Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Hi, I'm Murray Feldman. I'm a partner at Holland and Hart in Boise, Idaho, where I practice natural resources and environmental law, including several matters under the Endangered Species Act. Here today with my colleague, Professor Sam Kalen, and we are the co-authors of a book published by the ABA last year on ESA Essentials, the Endangered Species Act. In my practice, as I indicated, litigated a number of Endangered Species Act cases, and those cover different areas of the Act, including species listing cases, critical habitat designation, Section 7 consultation, and biological opinion cases, and even at the administrative level, petitions to delist a species and petitions to redesignate critical habitats. So not everything, but a broad range of ESA issues, and have been doing that type of work for at least the last 25 to 30 years, and environmental law practice generally for about 36 years at this point. Sam, what about you?
Well, I'm not sure how many years because I try to ignore that, but yeah, I am the IU McKinney Family Chair in Environmental Law at IU McKinney Law School in Indianapolis. And prior to that time, I was also a professor at the University of Wyoming College of Law, but also I practiced law for many years in Washington, D.C., and also was in the Clinton administration, where both in private practice and during my time in the administration, I worked on a whole array of issues involving the Endangered Species Act. So whether good or bad, I have been working on ESA matters at least since the late 1980s. I'm not sure if that meets the number of decades you've got, Murray, but yeah, and welcome everyone. You know, we're really excited about the book that was just published. I mean, this is a propitious time, we think, to really have a conversation and take a look at the Endangered Species Act, you know, where it's been and where it's going to go. And so I guess my question to you, Murray, first would be, you know, really what's going on now that really might drive a increased interest in really taking a look at the act and knowing how it works?
Well, I think some of the things are, I guess we'd say there's some increased friction maybe in efforts the current administration is making to yet again redo some of the Endangered Species Act regulations, and especially as we talk about the interagency consultation process. And this is when there's some federal action or activity, and that may affect a listed species or designated critical habitat, and then that action agency, be it the Forest Service or the Department of the Interior entity that may be engaged in offshore oil and gas leasing, or Department of Transportation improving an airport runway or a highway interstate project, whatever the broad reach of a federal action could be, has to consult with one of the expert wildlife agencies, either the Fish and Wildlife Service or the National Marine Fisheries Service, on the potential effects of that federal action on listed species or designated critical habitat, and has to, under the act, the service has to ensure that that federal action is not likely to jeopardize the continued existence of a listed species or destroy or adversely modify designated critical habitat. So there's a lot of activity in that area right now, where I believe it was just last week, after 6-7 years of litigation, a federal district court in California, in the Northern District of California, set aside regulations that had been promulgated in the first Trump administration and then revisited by the Biden administration. Let's just say adjusting some of the standards that were used under Section 7 for those consultations. So that just happened. And at the same time, the current administration is announcing new proposed changes to those regulations, and interested parties are trying to anticipate, are those new regulations perhaps doomed or dead on arrival, given the court decision about the former and some were the former and current regulations, how those will interact, changes to the harm regulation and the definition of what it means to harm a species under the Endangered Species Act, which has been a long-running issue and was the subject of a earlier Supreme Court decision. So there's a lot going on in that area. And then to throw it back to you, I'll leave you with another recent thing. Again, just last week, we had the meeting of the Endangered Species Committee, what is colloquially, but perhaps not entirely secularly referred to as the God Squad under the Act. And they met to consider, and I believe approve, the type of exemption to the endangered species requirements for forward-looking oil and gas exploration activities in the Gulf of Mexico or Gulf of America, depending on your point of view.
Yeah, I think that it really illustrates, if you will, the importance of really understanding where the act has been, where it's going, because what the administration just did last week, and you'll note that, in the discussions where you had all of the presidents or a number of the presidents, top advisors, the cabinet level folks who will participate in what we colloquially will refer to as the God Squad, it's the Endangered Species Act Committee, if you will. But in that discussion, the chair even talked about, the importance of looking at what the Endangered Species Act has done, and the suggestion was that they needed to exempt certain activities in the Gulf because they could impede the ability of oil and gas activities to proceed, and that hindrance, if you will, was going to raise a national security concern. And so the Department of War, the secretary said that there's a national security, and therefore we ought to exempt those types of actions moving forward, particularly as it relates to litigation involving oil and gas activities involving the rice whale in the Gulf. But what that does is, not just on the committee, really does illustrate that folks are looking again at the importance of the act, how it operates. And I think that it's going to end up fueling, if you will, a lot more inquiry into the act, and how folks are going to be looking at the act. Are they going to be looking at provisions that have not been tapped in the past? So what just happened last week was a provision of the act that was put in place after the act was passed in a subsequent amendment, but it's never been used. And so it's the first time we're taking a look at an issue that has been embedded in the act now for at least a couple decades, and trying to figure out, okay, how's it going to work? There's current litigation about that. So I think it dovetails with those things that you mentioned, Murray, about really trying to take a hard look at the act and understanding exactly how it works. But with all that, I would sort of ask you the question about, okay, well, with all these changes that the administration is proposing, does that make a book on the ESA somewhat almost dead on arrival, if you will? Because there have been a couple books, and ours might be one of the most recent books written. We noted that those regulations were being promulgated and being proposed, but does it mean that our book's going to be the book's out of date just automatically because of these changes?
Is the book already relegated to the dustbin of the law? I would say no. I would certainly hope not. In part because we knew at the time we were, working on it last year and the year before that in 2024, that many of these changes were afoot. But fundamentally, and the recent court decision that we talked about from California is an example of that. Fundamentally, the statute sets the framework, and that's how we tried to also use that as the baseline for our book and provide that outline and flesh out the statutory structure and explain the history of the decisions and regulations that had been promulgated within that statutory structure. So even though it's a dynamic situation, there's still value to that, basic ESA essentials, and also value to, understanding what has come before, how over that initial 50 years of the act, the services, Fish and Wildlife Service and the National Marine Fisheries Services, have both interpreted and applied the act. And so even though the regulations are in flux, and even though, depending on what happens going forward with the decision from California, how that is handled on appeal and how the services respond to that, even if some of those regulations that were described as the then current status within their historical context in the book change, it's still that structure and that historical value and those examples of all the excuse me, past cases that are in there that will help.
If I understand you correctly, you're really what we're suggesting, or you're suggesting, is that the nature of these types of books, the Essentials series, is really important to understand because it provides the structure, it provides the regulatory overview, if you will, of the statute. And so while regs might get tweaked or changed or litigated over time, that basic structure, the essentials, is there. And so the importance of sort of what was just written really provides the reader with an opportunity to understand what that structure is and to take a look at, if there are going to be any tweaks moving forward in the future, what is going to be the consequence of those tweaks? Are they significant? Aren't they significant? And what might the impact be to those folks who might be impacted or interested in figuring out how the ESA works? And I guess along with that, though, I guess I would ask, there obviously are going to be further court developments, but you mentioned, for example, the California case. These types of pieces of litigation can take years. And so we never know ultimately what's going to happen with a particular reg because it's going to unfold over a long period of time. But what we do know is that some cases stay around for many, many years. For example, in the Klamath, as you know, the administration ended up rescinding a deal for sort of the operation, if you will, of the Klamath River Basin system, or the Columbia River Basin system in the Klamath. And that ultimately caused the court to go back and revisit and issue a new opinion under the Endangered Species Act. So does that also reflect another kind of current development, that the act itself and the structure of the act is still there? Courts are enforcing aspects of the structure of the act, regardless of some of these changes in the regs, if that makes sense.
Yes, I think that's absolutely right. Like to say, the act sets the foundation, and I think what's interesting too there, Sam, is you see it not only in the Endangered Species Act, but I think it's fair to say a lot of the same type of thing is happening in the NEPA, National Environmental Policy Act context right now, where in this administration you sort of had the removal or a depromulgation or rescission of the Council on Environmental Quality Regulations that you and I and everybody else had just sort of taken as a given since about 1982 or so, with some changes to it. But that doesn't mean that courts have stopped applying NEPA. They're still looking to the statute. And what I like to tell people in that context is, think about it. National Environmental Policy Act of 1969 actually passed in 1970, but until the CEQ regulations were adopted, early versions of them, I think in 78 or so, and then amended in 82, there was a time period when a lot of significant NEPA cases were being decided by the courts with no regulations at all, and just some guidance, and courts looked to the statute and interpreted it. And I think what you're describing is exactly the same thing in the Endangered Species Act context, that the statute, the statutory terms, what did Congress mean, especially with, the new rules from the Supreme Court about almost liberating courts, you could say, liberating the federal courts in some way to look for that best interpretation of the statute. It seems in this era of regulatory flux that may become even more important and empower the judiciary's role in interpreting and applying the Endangered Species Act.
And if I recall correctly, in the book, we even noted that Loper Bright was going to focus a lot more attention on some of the statutory language. And so a lot of the cases that get discussed and looked at by folks who look at and write on the ESA are based on the statute, not necessarily on the regulations per se. The regulations might have the procedures, but in terms of the substance of the act, a lot of it does go back to, if you will, the statutory language. And now, after Loper Bright, that's just going to be even more important. So I think that, when we were writing the book, we sort of understood that some of that would obviously play out over the next several years. So with all that, I mean, there's some other changes too and other issues that are sort of percolating as well. We know that, for example, experimental populations have become an issue of recent concern, in part because of climate change and the need for species to look for and to have species relocate to new habitat. And we know that Congress has looked at, again, having and looking at the, if you will, experimental population program. We know that there's concern by the current administration about the wolf reintroduction in Colorado. So are those additional types of things that are going to focus people's attention on the ESA as well?
I think so, yes. I mean, it's interesting, like even after 50 years, how it can almost still be a new discovery, as you mentioned, little Sam, or the new applications of the act, or in the case of experimental populations, applications of provisions that have already been applied. For instance, when Bruce Babbitt was Secretary of the Interior and the reintroduction of wolves to central Idaho and Yellowstone, but then, coming around again and some 25, 30 years later, again becoming sort of a top line above the fold, to refer to the old print journalism standard, above the fold type issue. And fascinating too with your earlier example with the God Squad, how Endangered Species Act issues rising to that national profile, and with national security implications. It might be fair to say, Sam, that in terms of the importance and just sort of role in the national consciousness there, maybe at no time since the spotted owl controversies and the Northwest Forest Plan of the early 1990s has there been so much attention being paid to the Endangered Species Act.
Oh, I couldn't agree more. I think that this is perhaps one of the most interesting or propitious times to really take a look at the act, because, as you said, we're talking about the use of the act in an instance where it's never been used before. We're talking about changes to the Section 7 consultation process, talking about possibly a significant change to how we look at take liability under Section 9. You had mentioned the proposed change and removal of the concept of harm, including, if you will, habitat modification. And that's going to be a significant change. And then, coupled with all of that, we've got obviously iconic species that are pressing folks for, if you will, removal from Endangered Species Act protection, particularly the wolf, as well as the grizzly bear. So I don't know that in my years of doing work in the ESA arena that we have seen so much disparate and activity on so many different levels involving the ESA. And maybe you're right. I mean, it might go back to maybe the Clinton administration when there were a lot of changes to the Section 10 habitat conservation program, and when Secretary Babbitt initiated a number of changes to facilitate the use of Section 10. But I think today we're seeing a lot more activity than even then. I don't know if that's your sense as well.
I think there's certainly a lot of activity, and depending on how the midterm elections go, I think we may see some proposals start to move through Congress for what we've seen time and time again over the years under the rubric of, or the nomenclature of, ESA reform or streamlining the ESA. But I think there's folks that are working on that now and thinking about whether the time is right, and not to float some specific legislative changes, but maybe more of an overarching legislative reworking of the Endangered Species Act, with the motivation being all of these high level and visible issues we've been talking about. Now, it's an interesting comparison, I think, to take, like you mentioned, the changes in the Clinton administration, where, as Professor J.B. Rule described it, it was something along the lines of, how to change the implementation of the Endangered Species Act without changing the law. And it was all done administratively, and on the regulatory front. And really, the Clinton Babbitt administration, I think it's fair to say, we're masters of that, and seeing how much could be done at the administrative level to move forward and guide and come up, in their view, with creative ways to apply and implement the Endangered Species Act. So I don't know. I haven't really thought about it. Is it happening the same way in the current administration? I suppose to some degree, because of these changes to different regulatory definitions under the Endangered Species Act, like the harm definition, or the forthcoming changes that we know the administration wants to make to the Section 7 regulations. So they're certainly pressing that regulatory front, but I don't know. I almost have the sense that the effort is broader in some ways now to drive and invoke change in the Endangered Species Act implementation in this administration than even in the Clinton Babbitt administration, and maybe the convening of the God Squad committee. Maybe that's an example of that, because that seems like that's more than just an administrative rulemaking action. And the penchant for executive orders in this administration, and the secretarial orders, and just the direction coming from the top to all the levels of the agency, it seems like a more pervasive effort to change, mold the implementation of the Endangered Species Act sort of in the image or in the policy direction that this administration wants to go, maybe even more so than Clinton Babbitt times. But I don't know if it's one of these arguments like who is the greater player of this era in baseball or football or something. Can you really compare it across administrations? But I don't know. What do you think?
Well, I mean, I think that obviously it's really hard to say in terms of the uncertainty of change and which administration is pushing the boundaries more than perhaps another administration. But I think it's fair to say that right now, given the effects of climate change on species and on species habitat, that as these changes to the ESA unfold amidst a world that is changing around them, it's going to be a really interesting time to try to figure out how to mesh the original principles of the Endangered Species Act with a lot of what we're going to see unfolding over the next couple of years. So it's going to be a really important time for folks to focus on the Endangered Species Act, to focus on where it's been, to focus on the essentials of the act, to focus on its structure and how it has been implemented, and then looking at what those changes might look like in the future and how those changes are either going to be beneficial for species or adverse to species, basically survival and recovery.
Well, I'm glad you brought up climate change, because I was thinking about that and thinking about it in this context. The conventional wisdom is that folks in generations younger than us are more concerned, or perhaps have a higher level of concern about these issues, and worry about their future and the environment being left to them. And so I was wondering, with your students, what are you seeing, if you're seeing anything in terms of just their attitudes or feelings or thoughts about the Endangered Species Act, and even if they have it that refined, the interaction of the Endangered Species Act and climate change concerns?
I think a lot of students that we have seen, at least in the modern era, are obviously exceedingly concerned about climate change. And I think that they also have expressed an incredible interest in the Endangered Species Act. Whether or not the students are in different parts of the country and experience the act in different ways, they still all generally, at least in my experience, have been really concerned about whether or not species are at risk. Now, there have been differences in how they take a look at the procedures about ensuring protection for endangered or threatened species. But with all that said, I think we see, just like with climate change, an increased interest in making sure we don't lose species. And obviously, these are species that maybe these students, when they get older and their children, they're going to want to be able to observe and make sure those species are still around.
Yes, it's an interesting point about observing the species in the future, because as you may recall, it seems the conventional or oft-stated wisdom is that when the act was passed in 1973, and I believe they often reference statements of Senator John Tunney from California at the time, that folks in Congress thought, yeah, this is going to protect the gray whale and the African elephant as sort of these large charismatic megafauna. And then nobody thought about the Delhi Sands flower-loving fly, or the American burying beetle, or various plant species, and all the realm of flora and fauna that falls within the. I don't know what the current number is, but I think we were looking at somewhere around over 1,700 listed species in the United States. So it's really become quite a large regulatory program. And again, the conventional wisdom would say exceeding even what Congress could have foreseen in 1973. But also, I sometimes refer to the ESA as like the third rail of environmental policy. And to try to go into Congress and change it, it always seems like just attracts a lot of attention from the interest groups and the ENGOs, and almost a red line. No, we're drawing the line here, and we're not going to let that happen. So do you think there's any opportunity for legislative, call it reform or change to the Endangered Species Act in the next few years, or you think we'll continue to see what we were talking about, these administrative efforts, and even what we might say, creative or innovative efforts, like with the God Squad, to use untested or seldom used provisions to try to advance the administration's policy agendas in those areas?
Well, obviously, it's hard to predict what the current Congress might or might not do, and whether the Congress will change, obviously, within the next year. But I think that it's important to appreciate that it was a bipartisan effort when the ESA was passed, so it was not a political effort; it was bipartisan. And even in the 1990s, there was a bipartisan effort to amend the Endangered Species Act with fairly significant types of amendments. This was during Secretary Babbitt's tenure, and there were Republicans and Democrats who agreed on sort of a compromise amendment, and that got effectively curtailed at the last minute, or at least toward the end of sort of that bipartisan effort. So the ability to think about a future bipartisan effort when it almost occurred back in the 1990s is really difficult. But what I would suggest, as we think about the fact that while there was a bipartisan effort in the 1970s, and you mentioned that maybe Congress hadn't thought about, the breadth of what the act would ultimately look like by now in the 2026 period, it's important to appreciate that we now are in a different era. We are seeing extinctions at a rate that we had never seen or thought about back in 1970. So it's not odd that Congress might not have contemplated it, because obviously since the 1970s, the rate of extinction has just increased dramatically. So I think that sort of explains why Congress might not have anticipated what would happen ultimately.
Yes, and when you think about it, it seems like the Endangered Species Act was maybe coming in as sort of the ground floor of nascent concepts of biodiversity conservation, and early publications of books like the Extinction Crisis, and it was really an early adopter, I guess you might say, in that area, which I guess both suggest maybe the foresight that Congress and the sponsors and promoters of the Endangered Species Act had at that time in the early 70s, and also maybe in a more rational, less polarized public policy world, suggesting the need for maybe a strategic look or readjustment, because what piece of legislation, with relatively minor amendments since 73, probably the most significant coming in 1978, and some of the reworkings of the Endangered Species Act, after the Tellico Dam snail darter issues, and the adoption of the God Squad provisions at that time. But what
And
piece
then
of
also,
legislation?
don't forget Section 10 in 1982.
Yes, yes. I'd say those are sort of the big landmark changes, amendments expansions of the act in 78 and 82. But if you try to think about it, I mean, in any area, what piece of legislation that's 50 plus years old has had two major amendments, the last of which was over 40 years ago, could not maybe be, due for, say, a tune-up or a checkup, to try to make it adapt to current times. So it's interesting, I think, that in the hardline stances that folks need to take, where they seem to line up either on it needs some overall restructuring and reworking, or no, the ESA is sort of like the Constitution, which, as we know, even itself was designed to be amended. But the ESA is like the biodiversity Constitution, and is sacrosanct and should not be changed. That maybe there's not a role for, again, like we say, just some more objective, bipartisan, less polarized review. And here's an idea we'll throw out. Is it even time for, instead of something like the Public Land Law Review Commission of the 70s, do you have a commission to review the Endangered Species Act? A bipartisan blue ribbon commission to review the act and suggest changes and improvements.
Well, I guess my only response to that would be that we have not seen that type of effort in quite some time. The idea of blue ribbon commissions, obviously we had one on the budget. I forget when that was, when former Wyoming senator was part of that. You had a bipartisan effort. We have seen those only in a few times, and they have been obviously somewhat productive, but it's an old style view of legislating. And, whether we can get there in the future, some of us might be hopeful that we can, but I'm not going to predict either way.
All right. Well, it's been a good conversation. Any closing thoughts, either about our book or the future of the Endangered Species Act in the next 50 years?
Well, I think that it's fair to say that the act will stay around for a while, unlikely to change dramatically, at least in the near future. And so the book and the idea of understanding the essentials and the way in which the act operates is still going to be important for folks. And so I think the book is still a timely book and an important book for folks.
And I would add, for as you're seeing in your classroom training, that next and helping teach that next generation of environmental and Endangered Species Act lawyers that will be working on these issues going forward.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/envira. Please check where you found us for future episodes. Thank you for listening.